Professor Knipprath, welcome to Constitutional Chats. We'd love it if you just give us an overview of the Seventh Amendment, and then we'll go into questions.
Sure. Thank you for having me on again. It's always a pleasure. The Seventh Amendment is not one of those that jumps out at people when we talk about the Bill of Rights. It's a fairly limited effect. But what it does address is the right to a jury trial in civil cases, that is, cases where somebody is suing for someone else, say for an injury that the person has suffered. And the amendment grew out of a concern that the role of the jury, the historical role of the jury in Anglo-American tradition, would be curtailed by the existence of these federal judges. There was a distrust of federal courts that turned out to be somewhat unwarranted, but that's what people were thinking at the time. So what they wanted to do was to preserve the existing delineation between the role of the judge and the role of the jury. And that the jury's role was not to be diminished. So when you see in there basically that this is going to apply, this civil jury trial right, in all suits at common law over $20, that's what they were getting at. We don't want to diminish the role of the jury in civil cases. Now you might say, well, $20, that's nothing. We have to remember at the time that was about an ounce of gold. So we're talking about current value of roughly close to $2,000. The key, and by the way, the court has said it's still today $20. We don't adjust it for inflation. So theoretically, you still have that. Theoretically, you still have that right when there's an excess of $20. But we can talk how that doesn't always apply. The limitation that these be suits at common law. We look at what kind of suits were tried at common law in 1791. We're talking about Bill of Rights Day in December. Well, that's when the Seventh Amendment, the rest of the Bill of Rights, came into being by the actions of the states. So that's what we look at. What kind of suits were tried at common law in 1791? Not today, but then. What might those be? Ordinary, today, car collision cases, or cases where someone's tree roots are intruding on someone else's tree roots. Those kinds of things were triable at common law. Now, that doesn't mean that the federal courts could hear those cases. That will depend on another section of the Constitution, Article 3, Section 2, that we can talk about. But that's what we mean by suited common law. What was not a suited common law? Well, for example, marriage and divorce issues, probate issues when someone died. Why were those not issues at common law? Because the tradition in English courts was those were tried by what were called equity courts. So actions that were at equity, purely at equity, were not going to be tried to a jury. And that tradition more or less continues. It was certainly enforced in 1791. So you don't have federal courts here having jury trials in probate cases. You don't have federal courts hearing divorce cases and jury trials. In fact, in state courts, you typically don't have jury trials for those because, again, historically, those kinds of issues were tried in what were called equity courts. Originally, before Henry VIII, they were tried in church courts, courts of the Catholic Church. So that's a distinction then that is very clear in the Seventh Amendment. Only those suits triable at common law in 1791. Well, since 1791, a lot of laws have been adopted. A lot of securities regulation laws, laws dealing with labor matters, laws dealing with civil rights issues. And there's always a question whether or not those would be triable to a jury in federal court. What the courts will have to do is to see if there's an analogous action to that at common law. And if there isn't, then the case does not get tried to a jury in federal court. And that's a somewhat complicated matter, trying to figure out whether or not something is analogous to a suit that would have been tried to a jury at common law. But what you see here is the importance of the Anglo-American legal tradition coming through in the Seventh Amendment, and this what we sometimes refer to as original understanding. The Seventh Amendment is rife with this approach that we have, that the Constitution means what it says, but they understood when the Constitution was framed, and the framers are those technically who adopted, in this case, the Bill of Rights. Now another part of the Seventh Amendment says here that no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. What that was about was, we want to make sure that when you have appellate courts, they don't interfere with the traditional rights of the jury to decide matters of fact. It's the juries that decide matters of fact. So we don't want to have appellate courts reviewing those matters of fact. And that's the rule. Appellate courts cannot overturn a fact finding by the jury as such. They can overturn legal rulings, but they can't overturn because they disagree with an evaluation of the facts. And this is different from a number of other systems, foreign systems, where appellate courts can disagree with the factual determinations of a trial court. Indeed, our system is much more protective, at least in theory, much more protective of a right to civil jury trial than pretty much the rest of the world is. So in other countries, you do not have this kind of right to a jury trial in civil cases. It's typically done by judges or assistant judges. So that's an important aspect of the Seventh Amendment, protecting the right to jury trial, at least in theory. Now note that the Seventh Amendment does not apply to state courts. It only applies to cases in federal courts. The Seventh Amendment has not been, we say, incorporated through the 14th Amendment against the states. So the states can follow different rules as to what they give as far as civil jury trial rights. They're not bound by the Seventh Amendment. The court has affirmed that in several cases. However, and indeed, even if a state court is trying a federal matter, and state courts can do that in some circumstances. If a state court is trying a federal matter, if you tried it in federal court, you'd have a civil jury trial right. In state court, you won't. So that's kind of limited reach then of the Seventh Amendment. So that's a bit of an overview. We can get into more of the details if you wish, or explore other questions as we go along here.
Well, thank you for that. That was a really great explanation. And I'm going to go to Tove in just a minute, but I want to ask a really basic question that I think it might just help our audience if we just get a handle on this at first. How would you describe in really basic or simple terms the difference between a criminal case and a civil case? What are some of the hallmarks that make something criminal or something that makes something civil? Because last week we talked about the Sixth Amendment, and that was all about criminal cases. So
So that's an excellent question. What are the hallmarks? So we can talk about some of the hallmarks of a criminal versus civil case. A criminal case theoretically addresses a harm that the defendant has done to the peace of the community. So in California, a criminal case, for example, is People versus Smith, all right? Because Mr. Smith, when he engaged in this criminal conduct, basically breached the social compact not to engage in such criminal actions and threaten the security and safety of the community as a whole. And that's what a criminal case technically vindicates, that offense against the community. Whereas a civil case, generally speaking, is intended to remediate the harm that Mr. Smith did to the victim. So it might be Jones versus Smith, Jones being the one who's been injured by Smith's actions. So you can have both a civil case and a criminal case arising out of the same transaction. Then what happens is that the criminal case is prosecuted by the public authorities typically, whereas a civil case normally, at least we think of it this way, is prosecuted by the individual victim. There are different standards of evidence that might apply. For example, you have more constitutional protections in a criminal trial than you do in a civil trial. Your right to confront witnesses, your right not to testify, to incriminate yourself, your right to have an attorney if you cannot afford one. Those are examples of rights that are protected, the double jeopardy rule, that are protected in criminal cases, but not in civil cases. You don't have those rights protected in civil cases. If you don't want to testify in a civil case, too bad, unless you say, hey, I could be prosecuted criminally for this, right? But if that's not an issue, you can't refuse to testify in a civil case, for example. So that's one difference. Another difference is the standard of proof that the plaintiff has to come up with. In a criminal case, we normally say this has to be what we normally characterize it as beyond a reasonable doubt is what the state has to show. Whereas in a civil case, it's more likely than not, or what's called a preponderance of the evidence is the normal standard. There are some exceptions to that, but that's the normal standard. Then finally, the typical resolution of the matter. If you are convicted in a criminal case, you can be executed, you can be imprisoned, you can be fined, depending upon what the particular crime was and what the law requires. In a civil case, the normal remedy is money damages to compensate you for your injury. There could be other remedies, such as an injunction against further such action, for example. Now, in the matter of the monetary damages is where things get a little interesting, and I don't want to over-answer this question, but there are it kind of blends, because you can have civil actions by, for example, a government agency, the Securities and Exchange Commission, that brings an action against someone who allegedly engaged in, let's say, fraudulent securities, stock sales. Well, they can bring that action administratively, and it's technically a civil action. But notice what's happening here. It's the government proceeding with this case, although it's an administrative agency, not the Department of Justice. The standard of proof is civil, more likely than not. Sometimes we use something called clear and convincing evidence, but it's not beyond a reasonable doubt. Do you have a right to attorney? Do you have a right, to a paid attorney? Do you have a right to confront witnesses and all that stuff? No, you don't, because it's a civil case. And yet at the end of it, you can be fined, the same as if it were in a criminal case. So you see this kind of overlap between criminal and civil. And again, without getting into the weeds here, but the history of it, going back in English, Anglo-American legal history, going back to the Anglo-Saxons, and then proceeding to the Norman invasion, there was a similar overlap between concepts of criminal law and tort law. And I'll leave it at that unless people have questions about it.
No, that's great. That's really helpful. So I'm going to turn it over to Tova.
Can you hear me? Yes. Okay, perfect. Thank you so much. This was a really fascinating look at the Seventh Amendment. And I was wondering if you could explain why the courts haven't applied this right to the states, whereas like other amendments have been applied. Like what makes the Seventh Amendment different?
Sure. And we have to note that not all amendments have been applied against the states. So this is one of them. It's simply deemed to be not one of these rights that's so fundamental to a free society that the courts think that, okay, we ought to incorporate that and apply to the states because of the historic differences, the significant differences that state courts had regarding jury trials in civil cases, and the historical domain that was the state's right regarding the trial of civil cases. The vast majority of civil cases are going to come up under state law, the vast majority. Now, you could say, well, that's also true for criminal law, and it is. But the idea that a criminal defendant ought to have all these rights protected is deemed to be more fundamental and important to the notion of a free society than the civil jury trial right under the Seventh Amendment.
Great, thank you. And then another question I had was regarding the $20, and you were saying how the courts have found that that doesn't really need to adjust for inflation. And I was wondering, like, why they found that it didn't need to adjust for inflation. And has there ever been an attempt to like amend it so it did adjust to inflation? Because I'm just wondering, like, in your opinion, does it sort of devalue the original intention of the amendment if originally $20 was like a huge amount and now it's like, what can you even buy with $20?
Okay, so I can approach this at several levels. First of all, let me plead my ignorance as to whether or not there have been amendments proposed. I don't know. I'm not aware of any. I can put it that way. The reason the court says it's $20 because it's $20. That's what it says. Right there. We have a minimum age for a president to be elected 35. Well, the life expectancy is a lot higher than it is today. So should it be adjusted upward that you have to be, 55 before you can be elected president? So they've said $20. That's what it says. Now, we could also say, you asked whether or not the framers would have wanted that to be adjusted. I don't know. The price level, frankly, was quite stable for the first 100+ years of the United States. We didn't have a Federal Reserve. We didn't have use of paper money as we do today. So the price level didn't change very much. So I'm not sure the framers actually did think about, well, should this be because prices are going to go up tenfold or what have you.
I see, thank you. That's a good point about the life expectancy. But I was also wondering, this is, I guess, more of a broader question, and you can answer it sort of how you like. But I just was thinking about the role of religion in courts. And I know that like a lot of European court systems, and like even today in a lot of other countries, like religion is sort of very explicitly embedded in the legal code. Like the legal system is based around like, oh, what does our religion think should be the moral standards and the punishment for certain acts, whereas the American tradition is, has a very secular court tradition where like religion, at least explicitly, is not the basis for whether things are considered like punishable or not, or what the punishment for that should be. And I was wondering, was that like, did that mark a difference for the time period, or was that like significant? How did we get the system that isn't as at least statutorily based on religion?
I would respond this way. The idea, which was expressed by a number of people at the time, that it's a secular nation composed of religious people. That's what we're looking at. So that said, certainly you can't get away from a Judeo-Christian heritage of looking at people as worthy individuals and therefore having certain rights, a sentiment that's clearly expressed even in the Declaration of Independence. You don't formally get into the religious system because the 18th century, in England, we're a long ways from having religious courts as they did at one time, which were in charge of matters that related to the family and the soul and so on and so forth. So I don't think it was simply part of and I don't want to overstress this point about secular view at the time of the Enlightenment, that we don't just incorporate a religious code. But again, it was a secular nation, a secular country based on a religious people, and there was a lot of discussion about the importance of religion. So I would say that though that the faith, religious faith, entered into at least subconsciously a lot of how they decided whether or not to protect certain rights. One other thing you mentioned, I forgot to answer in your previous question, it's a very good one, as to the $20. What comes into play here is Article 3, Section 2, which defines potentially the jurisdiction of the federal courts. And so you may have a civil jury trial right in federal court in suits over $20, but a federal court may not be able to hear that suit.
And Aubrey, would you want to put up Article 3, Section 2 real quick? Maybe that would be helpful as long as we're talking about it. So just for our listeners to take a look at. But Tova, I didn't mean to jump in. You keep going with your questions.
No, it's good. It's always great to go back to the text too. But I guess while Aubrey's pulling that up, I had another question. I guess it's sort of top of the mind because I recently got to vote for the first time. I filled in my mail-in ballot from college, and it was interesting to me how much of the ballot was spent on the election of judges, which is not something you necessarily think about. I usually think about electing my Congress people or my governor, but there were so many spots for the election and retention of judges. So I was curious if you could talk a bit about was this originally how it was that judges were elected, or how did this sort of come about, and how does that fit into the Seventh Amendment?
That's a state matter. That's not federal. We don't elect federal judges. They're all appointed by the president with the consent of the Senate. So that's all state judges, and state systems differ. California, for example, is very much as you described it, different states have different ways to do it. Some are openly partisan elections, some are nonpartisan elections, some are what are called retention elections, typically for the higher courts. The judge's name will be on the ballot, and basically you vote yes or no on the judge. And it's very rare that the no vote will prevail. It happens occasionally, but very rarely. As to and some systems, they're more similar to the federal system, that judges are appointed by the governor with the consent of the legislature. And the election of at least lower court judges is a tradition that goes way back because of the connection between the people and the judiciary. It was an attempt to try to control what could be the problem of the judiciary. In colonial times, the lower court judges were typically elected by the people or by the legislatures, whereas the higher court judges were appointed by the crown. And we kind of see some of that distinction continuing in the system that you described. But that's a whole fascinating topic, and we could spend a better part of an hour talking just about how state court judges are selected.
Oh, I'm sure. I guess my final question, I wanted to ask about jury selection. We know we have the right to jury in some cases, but how is it chosen who gets to judge us?
Well, okay, so typically you're enrolled in the jury rolls, and today that's very broad. In the past, that wasn't always exactly that way. So if you get a driver's license, if you vote, the state has different ways to put your name there. And then your name comes up periodically when they need to select a pool of jurors for cases, and I'm going by California experience, that day. And so you go down there unless you have a very good excuse. You go down there and then you sit in the jury room and the jury assembly room, I should say. There typically will be a judge that will make introductory remarks about the jury system, and then there'll be administrators that'll be sitting there with you. And if a request from a trial judge comes in for a jury panel, then they will draw names for that jury panel. And then you go to the courtroom, and then there will typically be an examination that will be conducted by the plaintiff's lawyer or the prosecution if it's a criminal case, and by the defense lawyer. The judge can also ask questions of you. This is called a voir dire. And then the attorneys can challenge you for cause. Let's say that you're married to the plaintiff. That's a for cause dismissal. And there's an unlimited number of for cause dismissals, but you have to prove that there's a reason for it, right? Bias or something. So if somebody is, knitting a little noose in a defense case, a criminal defense case, that would be cause to dismiss, right? In addition, there are what are called peremptory challenges, not challenges for cause, peremptory challenges, which there's typically a limited number to that, different in civil versus criminal cases, and then different in capital criminal cases, much bigger than in ordinary criminal cases. Peremptory challenges are those where the attorney can challenge for any reason, doesn't have to show cause. It's just the attorney may get kind of a weird sense about this juror. The juror's not telling the truth, or the juror seems rather, sort of ignorant of life, if you want, or things going on in life. You don't want that person on the panel either, so you issue a peremptory challenge. Peremptory challenges cannot be used for purpose of racial discrimination or discrimination on the basis of sex or on the basis of religion, but they can be used for these other reasons, just bad vibes, as the phrase is.
Great. Well, thank you so much for that overview. I really appreciate your time. And now I will pass to Jewel and Jordan.
Hey everybody, we've covered a lot so far. It's a very nuts and bolts type of issue here as we talk about what goes through the courts and like procedures that we don't really see that much, or don't seem to be as political as some of the rest of the Constitution in the way we think about politics. So if we're just some quick questions to get it to be a little bit more practical, what types of civil cases are on a lower level are federal?
Okay, so Article 3, Section 2 gives you the potential reach of federal jurisdiction, okay? And so federal courts can't go beyond that. Typical federal cases would be, well, let me back up. So it's not just everything that is in Article 3, Section 2 that the federal courts, in fact, exercise. It takes a statute from Congress called a Judiciary Act, then to confer status on the lower federal courts. Indeed, Congress can eliminate the lower federal courts if it chooses to do so. Only the Supreme Court is constitutionally guaranteed. So the typical types of cases that federal courts will hear, one would be criminal actions where the behavior was a violation of a federal criminal statute, right? Kidnapping someone and transporting the person interstate or something like that, right? Suits against the United States. Let's say that an FBI agent negligently shoots you. So suit against the United States will be tried in federal court. But most cases that are going to come up in federal court are cases that arise under some federal statute, such as a Civil Rights Act, or a federal antitrust law, or federal securities laws, or where you have a contract or where you have, let's say, a contract dispute between citizens of different states. These are called diversity actions. Right? So diversity actions and federal question actions, that is, claims that arise under a federal statute or the US Constitution or a treaty, those are going to be tried in the federal system typically, or at least possibly. The reason I say possibly is because in many cases, a federal type claim can also be tried in a state court. So a diversity lawsuit could also be tried in a state court, not in the federal court. Only if the federal court jurisdiction is said to be exclusive by Congress, such as actions against the United States, crimes, federal crimes. Those are exclusive in the federal courts. But if they're not exclusive, then there's concurrent jurisdiction in the state courts to hear that case. Federal courts are not going to hear an ordinary car accident case, most likely. Federal courts are not going to hear the typical, contract dispute. Hey, a buyer, you didn't pay me for the stuff that I shipped to you. Those are going to be handled by state courts. The suit over some property title, that's going to be handled in state courts, right? For one reason, because, and this is where the $20 comes in, issue comes in. For one reason, because Congress has said that if you have a diversity suit, a suit between citizens of different states, let's say, I ship you something that's worth some amount of dollars, and you don't pay me. We have a contract dispute now. So I sue you, but the law says, not the Constitution, but the federal statute says, you can only have this diversity suit, you're in Pennsylvania, I'm in California, if I have a claim that exceeds $75,000. So if that claim exceeds $75,000, I'm suing you for $100,000, then we can go into federal court, and then I have a jury trial right because it's over $20, protected by the Seventh Amendment. But just because we have a dispute over $20 doesn't mean I get to go to federal court, because if I sue you for $50,000, I have to go to state court. And the state court isn't bound by the Seventh Amendment. So they might have a rule that unless you have a claim for $100,000, you're going to get a jury trial. It's not worth our expense.
How is it resolved between two states if in that simple example there where there's a contract? Which state would it normally be heard in? And what if the person who loses tries to appeal to their own state courts?
Okay, we're really getting into some deep issues here. I'm just preparing a course to teach on those issues for next semester. But all right, there are various rules that are set up, and I don't want to really get into all the weeds of that. But basically, you're going to bring a suit in a state court that favors you. So I'm going to try to bring the suit in California, right? Because it's convenient for me. I'm here. I know California law, and maybe you're from Pennsylvania, and I'm hoping that if I get a California jury, maybe they don't like people from Pennsylvania. They prefer their local boy here. Well, you're going to think about, I don't want to be tried in California. That's a long ways to go, and they may not like Pennsylvania guys. So I want to have it tried in Pennsylvania, where we know they don't like California people. So you want to go to Pennsylvania. So how do we resolve that? Well, one way to resolve it is, does the court have jurisdiction over you? If you've never been to California and everything we did happened in Pennsylvania, let's say, then California courts don't have jurisdiction over you. They have jurisdiction over people and things in California and events that happen in California, potentially. So I'm going to have to go to Pennsylvania then, right? And this is, again, this can get into real difficult issues as to what is enough of a contact between you and California that I could sue in California. But the basic rule is going to really boils down to, does the state court have jurisdiction? That's, and the reason we require that is the due process clause, because it's fundamentally unfair to have you be sued in California when you don't have any connection to California. All right. So I'd have to go to Pennsylvania because that state really does have jurisdiction over you. You're a citizen of Pennsylvania, let's say.
It's interesting. So getting back to the Seventh Amendment more so, there's the when it at the beginning of the phrase, when it refers to common law, and you said common law a few times, is common law just mean the laws in effect currently, or is it referring to a phrase of the period?
Yeah, it's a term of art. Common law can mean many different things. So what it means in this context is those claims that were tried by the common law courts, that were recognized by the English courts as matters covered by the common law. So as I said, it didn't include probate, when someone dies, will admissions, distribution of estates. It doesn't apply to marriage and divorce, family law matters, because historically that's not what it meant to be an action of common law. It doesn't apply to actions where all you're seeking is an injunction, let's say, a writ, because those extraordinary remedies were not treated as actions at common law. They were treated as actions in equity, was the phrase. Today, we kind of combine those, but we still maintain that distinction, that if all you've got is a claim for an injunction, you don't have a right to a jury trial in federal court, because that's not an action in 1791 triable to a jury at common law. So that's what that means.
My last question before adjourns is, are you aware of any state that has adopted an amendment to have civil cases by jury? Or maybe whatever the lowest threshold is in a state of note that's a trial by jury?
I certainly can't speak for all the states. We do have, in California, for example, we have something called a small claims court. And the small claims court is not a jury trial court because it's not worth it. And I forget whether the limit is $7,500 or $10,000 at this point, dollar cases. So you don't have a civil jury trial right there. Then we also have what are called limited jurisdiction courts, which are limited jurisdiction cases in our superior court, which are at least used to be amounts up to 25,000. So again, there are different procedures for that. And I don't know if there's a right to a jury trial for that either. It's just a little bit more better protections as far as the procedures you have, but I don't know if there's a jury trial right. And then above that, you have a general jurisdiction claim in a superior court, and you do have a civil jury trial right in California. But same thing in California, probate cases, divorce cases, cases that are mere writs, don't get a jury trial right. You want to get a restraining order, you don't have a jury trial right. Those are all just dealt with by judges.
All right. Earlier you were talking, you almost got into the weeds about the crossover of criminal and civil, and that there was a little bit of overlap, but you said you didn't want to get too deep into it yet. But I kind of want to know. Could you just explain what you were going to say about that?
Okay, so part of this is simply, legal history, and it's of interest to legal historians. The question as to what occupied lots of writers in legal history. What came first, the criminal law or the tort law? And you go back in the ancient mists of Anglo-Saxon practice, and it was private plaintiffs would bring a claim. If I killed someone else, that person's family could exact the blood price. But instead, in order to not just get carried away, instead, what you would do is to try to sue me for compensation. And ultimately, it was possible for the king to be sitting in judgment of this. The idea was compensation and making the family over there whole for the act I committed. Well, eventually, so you have a kind of an overlap between criminal and civil there. And then you get in English history more of a division after the Norman invasion between the criminal system and the civil system. Those that were offenses against the peace of the realm versus those that were civil cases. But even there was some overlap. And the example I gave you, even in today's systems, there is still sometimes a situation where there seems to be an overlap between theories of criminal law and civil law. For example, a very common one, A sues B for a tort, which is an injury, a wrong committed, to get compensated. And A has $100,000 in injuries. but because what B did was so heinous, A also asks for punitive damages. All right. Well, a punitive approach is an aspect of the criminal law, not the civil law. Right? The civil law was to compensate you for your injuries. So punitive damages have a criminal type tint to them, let's call it that, coloring to them, which is why the Supreme Court has stepped in and said there has to be a limit to the punitive damages in relation to the compensatory damages. It's a matter of due process. So that starts us once again into notions of criminal law, right? And where it's most prominent is, as I said, in the context of regulatory agencies, state and federal, which typically do not bring criminal actions, they bring civil actions. Criminal actions are brought by Federal Department of Justice, the state attorney general, the local district attorney, and so on. So these agencies, such as the Securities and Exchange Commission, they bring civil actions. But as I explained before, in many ways, it looks like a criminal action, right? Because the end result of it is you might be barred from a job, you might have to pay a fine, but you don't have the protections of the criminal law. You don't have the right to counsel. You don't have the right to confront witnesses, the right not to incriminate yourself, the right to a jury trial, the right to all kinds of things that you don't have that you would in a criminal case.
All right, thank you. I think that really rounded it out for me, so I appreciate that.
Sure.
I think we have to jump on to some audience questions now.
Well, and thank you, Professor Knipprath. I feel like that we all ought to get at least some law school credits after this podcast today. You're really educating us. And I want to recognize our students that we have on with us today. We've got homeschool students with Terry Zalesnak and Cami Wainhouse, and Julie Adamson with North Island School is on. So we welcome all of our students. And I'm just curious if the students want to raise their hand, if there's any students watching thinking about going to law school. That'd be really interesting to know. But just to grab a few audience questions here, Sanford Thatcher asks, when does the 11th Amendment come into play in protecting states against suit under federal law?
Okay, that's another hour discussion we can have there. It's a very interesting question. The theory here is that the 11th, that the states cannot be sued in federal court without their consent. Now note that this technically doesn't apply to state court suits, but in state court suits, the states can set their own definitions of what's called sovereign immunity, that they can't be sued without their consent. So this arises out of this notion of sovereign immunity, which is that you cannot sue the sovereign. The king can do no wrong, was the idea, but you can't sue the sovereign because it's inappropriate for the courts to hear cases that are going to involve, say, monetary damage that have to come out of the state treasury. It's not the state courts or the courts' roles, federal courts' role to make appropriations, as it were, out of the state treasury. That's not their role. So this doctrine of sovereign immunity carried over from the common law. Now note that under Article 3, Section 2, which we talked about, the potential scope of federal jurisdiction, states can be sued. So very early on in our country's history, in the early 1790s, you have a case called Chisholm versus Georgia, where the Supreme Court says, oh yeah, a citizen of South Carolina can sue the state of Georgia in a federal court without Georgia's consent because it fits under Article 3, Section 2. There's a quick reaction and the 11th Amendment gets passed. So it was a reaction against that particular suit. Now, when the dust settles through further Supreme Court opinions, the state can still be sued in federal court without its consent if the suit is by another state or if it's by the United States, but cannot be sued in federal court by a citizen of another state. by a foreign country, by a citizen of a foreign country, by a citizen of the same state. All right. The state can only be sued in federal court without its consent if the suit is by the United States, because the United States is the sovereign that controls the federal courts, and second, by another state, because that's right there in the Constitution. All right. That's without, going really deep into it and talking about, okay, what constitutes consent? Are there exceptions for state officials under some circumstances, depending on the remedy? All those issues come up as well in this area of law, but that's kind of the very basic of it.
Okay, well, thank you. And then we had a question from Patricia going back to Aubrey. Could you put up the Seventh Amendment one more time? Going back to the re-examination clause and this whole issue that you can't overturn no fact tried by a jury shall otherwise be re-examined in any other court of the United States. Could you give an example of a fact? Because we said they can't overturn facts, but they
Sure.
can, there's other ways that you can appeal, but what would be an example of a fact that couldn't be overturned?
Sure. The idea here is, and there are some vague areas around the edges of this, but the idea is, let's say a jury finds that A killed B with malice aforethought, so with intent and premeditation. A killed B with that. The appellate court can't say, well, no, A didn't really kill B. Okay, A didn't really have the requisite state of mind. Wasn't malice aforethought. The appellate court can't say that. That's a fact, and that's dealt with by the jury, and the jury's use final. Now, let's say A was doing the killing. Okay, A is sentenced to death. Okay, I want to keep it in a civil case. So A's killed, and A's survivors sue B, and the jury establishes in the civil case that B in fact killed A and did it with the intent. The appellate court can't overturn that. The civil jury's determination of that is final. Now, if somehow the trial court improperly applies the law, the appellate court could overturn that.
Okay.
Okay. Or if some procedures weren't properly followed, the appellate court can overturn it based on that.
Okay, well, great. Thank you for that clarification. And then Eric Braverman writes, in legal battles that include assets in 10 states, should those cases be subject to a jury trial rather than be subjected to petty administrative judges and CPLR of states that still refuse to abandon their sovereignty to federal government? Many cases in civil law, such as international interstate corporations, divorces, civil rights issues, are about interstate assets. So why are they not subject to jury trial and more law?
I'm not quite sure I understand the question. I think the idea maybe here is that if you have connections to various states, why should that not be tried in federal court? If there, the case takes place in state A, but there are assets in B, C, D, and E states, why should that not be in federal court? Because Article 3, Section 2 defines what the limits of federal court jurisdiction are. So unless you're suing under a federal statute that is properly within Congress's power to enact under Article 1, then you don't have a claim. You're stuck in state court. So if A and B are getting a divorce, that's going to be governed by state. If they, let's say, both resident in state X, we'll keep it simple in California. Then California is going to be the place where the divorce action is filed. The fact that you have assets in other states the distribution of those assets will be determined by California law interacting with the law of the state where that property is located. But you're not going to get into federal court because you don't have a federal statutory question, a federal constitutional question. You don't have a diversity action because A and B are in the same state. They're not in different states. Federal courts are courts of limited jurisdiction. State courts are state courts of general jurisdiction. You do have sometimes very complex federal cases that are consolidated in a particular district court, even though there are connections to federal districts all over the place, all over the United States. So you have it consolidated, a multi-district complex litigation.
Okay, well, we are right at time, and we want to thank you for your great explanations today of kind of one of the more difficult amendments that I think we've been through in this journey through the Bill of Rights that we've been taking for the past few weeks. And we want to remind our listeners that next week, because of Thanksgiving week, we're going to skip next week, and we will be back the week after that with the 8th Amendment. So we hope you all join us. And I want to take a minute and thank just a few people that I know that are in our audience today. Amanda Hughes, who I think you know, Professor Knipprath.
Yes.
And Hope Mucklow and Sandy Thatcher have all donated items to our auction. And thank y'all for doing that. Sandy Thatcher donated a very rare edition of a book about founding Father William Livingston that is actually up to $150 on our auction, which is really great. So we do want to encourage everyone watching to go to the Constitution America website, hop onto our auction, and help us keep funding our Constitution education programs. And so, Professor Knipprath, thank you for all you do to make our programs possible. Thank you for being
My
with
pleasure.
us.
Thank you for having me.
And anything y'all want to say, Jewel and Jorn, before we hop off?
Thanks for a cool show, and this maybe we can get our law degree soon now.
Thank you very much.
Thank you. Thank y'all. And happy Thanksgiving, everybody.
Happy Thanksgiving.
Right.
Thanksgiving.